There's a say that all good things come to an end. And I can still remember the excitement. I've started several companies or several businesses in my lifetime, and I can remember the excitement every time that you ponder this idea. But unfortunately, it is true. Often things do not go according to plan. And this is what this whole learning outcome 5 is all about. We want you as students to be able to apply the law relevant to failure and or the cessation of business. People, I don't think there's any other topic with so much terminology involved. So my objective is simply, you will see the first more than 30 slides. We will just discuss different kinds of terminology that you will need in order to be able to understand everything about cessation of business. So, and then we will look at the 3 main types of external administration. And I can already give them to you. It's receivership. We're going to look at receivership, and we're going to distinguish that from voluntary administration. And then we will also look at liquidation, winding up of a business. People, we've got the following enforcement procedures available in debt collecting, but often when I talk to my students, they do not even know what a distress warrant is or what garnishee proceedings are. So I want you to stop the recording and first think about this, and maybe if you want to do a quick Google search, you can, and see if you can answer it, and then resume the recording. A distress warrant. People, a distress warrant is used to enable a local bailiff to seize the chattels owned by the debtor and sell them to satisfy those debts. And then when it comes to garnishee proceedings, I've made use of this myself. And so sometimes you will see that someone will owe money to a certain debtor. And you can then apply to the court for that money to be paid to you instead of the debtor. And the nice thing is, it can even be between an employer and an employee. If an employee is supposed to get a certain amount of money from the employer, then you can basically go stand in the gap and receive some of that money. I've worked through lawyers. In other words, the lawyers will take the debtor's place, or you, but the lawyers on behalf of you. In other words, they act as your agents, and at the end of the day, you will get your money back. 2 questions that I want to ask you. Why do we put a charging order on the debtor's property? And what is a judgment summons order? Putting a charging order on the debtor's property is very useful, especially if you know that the debtor wants to sell the property. So if the debtor owns property, you can apply to stop them from selling that property until the debt is paid. So to transfer ownership, that debtor must first pay the amount to remove the charging order. In the meantime, you as a creditor can claim interest per annum if the debt is bigger than $3,000 in New Zealand. You can also apply for an order for sale later to force him to sell and then pay you. Okay, people, the next thing that we want to look at is a judgment summons order, and this is really important. A judgment summons order, you must really know what it is, because we're going to come back to it. Is where the debtor is ordered to appear in court and explain why he or she has not paid. So a judgment summons order, the debtor is ordered to appear in court and to explain why he or she has not paid. What is judgment debt? It's when a court of law orders the losing party to pay a certain amount of money to the winning party. We simply call that judgment debt. And now I want to ask you, do you think this is civil law or criminal law? what kind of law will be involved? You're supposed to know because you studied commercial law. Of course, it will be civil law because the government is not involved. It's a matter between civilians. What does insolvency mean or implicate? Insolvency, what does it mean? People, it's one of the common grounds that leads to the cessation of business, and basically it means that the business is unable to pay its debt. Whenever you see that word in, like we know what solvency is, in other words, a business can pay its debt as they become due, but just by putting that IN in front of it, it will give it like the opposite meaning. Same thing if we talk about sane, a person is not sane, he's insane, then it's basically meaning the opposite. And the same thing with tested, for example, a person died with a will, he died tested, but the opposite of it is intested. In other words, there was no will when he died. What is a statutory demand? A statutory demand is a court document giving written notice to a debtor that he must pay the debt that is owed to the creditor. People, remember this. It's the first step in a legal proceeding to wind up an insolvent company pursuant to Section 289 of the Companies Act of 1993. So the moment that you get a statutory demand, people, it's not good news. If you receive a statutory demand, then you have 10 working days to dispute the debt. In other words, you must respond within 10 days. Otherwise, they will assume that you are not able to pay the debt. What does it mean to compound a debt? Compounding a debt means the creditor is accepting an arrangement for payment of the amount of the debt. Or people, if you're lucky, often for a different amount. So oftentimes people negotiate, and then the creditor, instead of not getting any money at all, is willing to receive a lower amount, or sometimes even a higher amount, a little bit of interest added, but over a longer period. The meaning of inability to pay debts. So unless the contrary is proved, and subject to Section 288, a company is presumed to be unable to pay its debts if the following is true. A, the company has failed to comply with a statutory demand. Now you see why I've told you it's so important to know exactly what a statutory demand is. Or an execution was issued against the company in respect of a judgment debt. What is a judgment debt? It's simply where the court ordered outstanding civil debt to be paid. So, it has been returned and satisfied in whole or in part. In other words, the execution issued against this company in respect of a judgment debt has been returned and satisfied in whole or in part. Or, C, a person entitled to a charge over all or substantially all of the property of the company has appointed a receiver under the instrument creating the charge. In other words, a receiver was appointed. D, a compromise between a company and its creditors has been put to a vote in accordance with Part 14, but unfortunately, it has not been approved. And the moment any one of these things happen, it will be presumed that that company is unable to pay its debts. Companies in debt are often placed into receivership. So what is a receiver? People, it's exactly what the name is saying. It's a person whose job it is to receive money. So receivers are only interested in realizing debts to recover capital and interest sums for the creditor or the creditors who appointed them. So realizing debts means to sell property in order to get money for it. So companies sometimes survive receivership, but often end up in liquidation. In other words, at the end of the day, they being winded up. And of course, then there's the eventual dissolution or the deregistration or the death of that corporate entity. So now you can see, even though we believe that companies have perpetual existence, usually the majority of them do not survive. Often companies can be placed into receivership or liquidation, and the reason for that is normally insolvency. But remember, it's not always like that, because receivership and liquidation are occasionally even appropriate where a company remains solvent at the end of the day. What is the difference between internal and external administration? This is basically my own question, because I think the moment that you can see this, everything will be way easier to understand. The internal control of a company simply means that it can basically function independently. In other words, the company can manage itself, making use of its own organs. But when there's external administration, people then, bodies from outside will come and basically take over the control of this company. And one example is, say for example, receivership. Receivership enables a secured creditor to enforce its security by appointing a receiver who will take possession of the collateral that is subject to the security with a view to repaying the secured party's debt. So that's in short what external administration is, one example, and that is a specific focus example that we've used is receivership. Voluntary administration involves another type of independent appointee called a voluntary administrator, taking control of the company for a short period of time, during which the company is protected from creditors who wish to enforce their rights. Liquidation, sometimes we talk about it as winding up, and it's simply when an independent liquidator sells the company assets and distribute the proceeds equally among the creditors. And usually, people, it will mean the end of the company's existence. Now I will go to my own receivership slides. I've inherited some of the ones above, and yeah, I'm still going to focus on terminology, and then we will move over into the different examples of receivership, or what exactly it is, and voluntary administration and liquidation. Amalgamation is when two companies join and carry on business as one company. And you can read more about that in the Companies Act of 1993, sections 219. What is a compromise? It's a cancellation of debt or a variation of rights, according to the Companies Act of 1993, sections 227 to 229. Deregistration, it's a removal of a company from the New Zealand register. A failed company is an insolvent company placed in liquidation, and you can read about that in the Companies Act of 1993, section 386B. Insolvency, it's when your liabilities exceed your assets. People, it's a factual inability to pay one's debts when they fall due. That's a nice definition. Liquidation, it's a process of realizing the assets of the company and distributing the surplus according to its rules. And you can read about that in the Companies Act of 1993, specifically Part 16. Pari passu, it's simply the principle that all unsecured creditors of a liquidated company should be treated equally. What is a Phoenix company? It's a company that takes the same or a similar name to a failed company that has been liquidated on the grounds of insolvency within the previous 5 years. So an example is in June 2012, Alpha Supplies Limited went into liquidation. And in June 2013, the shareholders of Alpha Supplies Limited form a company called Alpha Supplies 2013 in brackets Limited. So they've added 2013 in brackets to the name. Avoidable transaction, a transaction that unfairly benefits a person that the court can set aside at the liquidator's request. That's avoidable transaction. Just think back to your commercial law and then it will be very easy. Voluntary administration, it's a process whereby an administrator takes over the running of a company in financial difficulties with an aim of trading back to solvency. That's the whole purpose of voluntary administration. And you can read more about that in the Companies Act of 1993, Part 15A. Insolvency is simply when you owe more than what your total assets are worth, or you cannot pay your debts when they are due. So we often working with a solvency test. So just think about it. This insolvency is just the opposite. So people and businesses try and avoid the more drastic outcomes like bankruptcy or liquidation by trying to trade out of the situation or coming to arrangements with their creditors. In other words, that they will always first try to make arrangement with creditors or try to trade out of the difficult circumstances. But usually or sometimes, often it doesn't work. An insolvency practitioner is someone who acts as the liquidator or the administrator or the receiver of an insolvent body corporate, or it can be a trustee of an individual's creditor. Insolvency practitioners that's working in New Zealand must be licensed by an accredited body and listed on the register of insolvency practitioners. We all want to take our own decisions, but the purpose of law is to be an external regulator. In other words, if you can't behave, if your internal behavior is not good, is not accurate, is not acceptable, then we will regulate it for you. We will enforce the law on you. So the purpose of law is to be an external regulator. External administration is also a term which covers all types of insolvency arrangements. An external administrator is also known as an insolvency practitioner, or a voluntary administrator, or a liquidator. Company administration aims to help the company repay debts in order to escape insolvency if possible. That's the purpose of administration. Whereas liquidation, on the other hand, is the process of selling all assets before dissolving the company completely. There are many alternatives to receivership or liquidation. I've been involved in several of these processes myself when I've been working in the bank. But insolvency is usually the reason for receivership. In other words, we know what insolvency is. It's when you cannot pay your debts when they become due. I want to ask you something. What is the difference between shareholders and stakeholders? Just stop the recording, see if you can answer that one, even if you have to Google. Statutory management. People, sometimes the government will impose statutory management, and it simply means they will take over the management of the company. And it has been used occasionally in serious and complex situations of corporate collapse. So the objective is to preserve the interests of the creditors, the shareholders, and the public where a company may be operating fraudulently or recklessly, and where ordinary external administration or enforcement proceedings appear inadequate. The purpose of the Corporations, the Investigation and Management Act of 1989, People, it's simply to protect wider interests than just those of the individual shareholders. In other words, here it's about the whole market reputation. We do not want investors to panic. Otherwise, all over, people will not be interested in investing anymore because the risk is simply too high. You can't trust anybody. And that's why we have to intervene in serious cases of fraud and so on. The statutory manager that will take over has wide-ranging powers that are invoked on the advice of the Minister of Justice and on the recommendation of the FMA, the Financial Markets Authority. And this statutory manager is supposed to restrict further deterioration of the financial affairs of the company. And he must try to prevent any fraudulent activity or to protect stakeholder interests as far as possible. So that's the whole purpose of this whole thing. The Corporations Investigation and Management Act contains moratorium provisions that suspend the creditor's rights. In order to provide a breathing space to enable the statutory manager to sort out the company affairs. Think for yourself, if you hear that there's been serious fraud and you a creditor, I mean, all those creditors will just storm like a bunch of vultures and attack that company, and all will say, I want my money and I want it now. And this is why their rights are immediately suspended. So just for a time, in order to allow the statutory manager to give him a breathing space to sort out all the stuff of this company, all the company affairs. If you click on the following link, it will take you to a site where you can see the difference between a merger. We all know what a merger is. It is when two companies become one and continue to trade as one in future. An acquisition, in other words, is where one big strong company buys another company, and then it's also telling you about divestiture, in other words, where a company is selling maybe a subsidiary or a certain portion of that company, and then a spin-off, in other words, where a certain divestiture becomes a new company. In other words, instead of selling it to a third party, it can basically become a new company with an IPO. In other words, the initial public offering. Often you will hear the term restructuring, and it's kind of like happening very often here in New Zealand. At Tupukenga or Northtec, I've started here in 2017, and it's already our third restructuring. So restructuring involves reorganization. Reorganization is a process designed to revive a financially troubled or bankrupt firm. A reorganization involves the restatement of assets and liabilities, as well as holding talks with creditors in order to make arrangements for maintaining repayments. Reorganization is an attempt to extend the life of a company facing bankruptcy through special arrangements and restructuring in order to minimize the possibility of the same situation reoccurring a year or two down the line. Reorganization can also mean a change in the structure or the ownership of a company through a merger or a consolidation. We can think of spin-off, acquisitions, transfers, recapitalization. I will come back to recapitalization, or change in identity or management structure. So such an endeavor is also known as a restructuring. So what I want to explain to you is that while I've been working in the bank, it often happened that some of my customers came in, and then I saw, okay, their problems are basically of such a nature that they will not be able to pay their debts when they become due. And then I will look at their short-term debt and all their debts, and I will just consolidate the whole lot. and I will spread it again over a new term loan, in other words, where they have to pay it back on an annual base, usually when they sell cattle or when they expect the harvest income to come in, because I've been working mainly with farmers. And then it basically gives them the money that they already have available plus another year to save up before they have to pay the first installment. And then basically you just you ask them, you plead with them to be very kind of like careful in the way that they manage their finances, and you show them that if they go buy new vehicles and so on, they will not make it. They will have to cut on their expenses as far as possible and kind of like fall back on a type of a survival strategy. A company will go into external administration if there is no realistic prospect of reorganizing, restructuring, or rescuing that business. I've rescued many businesses. I've done many restructurings, but you come to a point where you just have to hand them over because you realize, okay, no, this person, there's no way out. Because eventually you get to a certain point where the debt load will just kind of like snowball, and then you realize, okay, they will not be able to handle this debt load anymore. There's three main types of external administration. The first one is receivership. The second one is voluntary administration. And the third one is liquidation. And I've already told you we often talk about it as winding up. I basically started with this and I told you this is what we're going to look at and focus on. So the question that I want to ask you, what is receivership? We've already touched on it. Your answer is in the blue. A receiver takes possession of the collateral or securities with the intention to repay the secured party's debt. People say you can distinguish it from voluntary administration, and that's why I've put it in green color. And this is where a voluntary administrator takes control of the company for a short period. During that time, the company is protected from the creditors trying to enforce their rights. At the end of this period, the creditor can vote for a reorganization plan or liquidation, or it can be returned to the control of the company by the company directors. In other words, it can be given back to the company itself for internal control instead of external control. And then liquidation, or the winding up, it's an independent liquidator selling the company assets. Why? Basically to get it liquid, to get it in the form of money, and to distribute the proceeds equally among the creditors. And usually people, this means the end of the company's existence. People, when we talk about receivership, usually this job will be handled by a chartered accountant. So receiverships are governed by the Receivership Act of 1993 as reprinted at 1 September 2020. A receiver can be appointed by the court or a secured creditor with a contractual right. Say for example banks. That's where I've been worked, and we've often appointed receivers. But the receiver does not include a mortgagee. For example, a bank that wants to enforce its rights. In other words, we can't be the receiver ourselves as a bank. We have to appoint a receiver. So technically, a receiver with the rights to manage the business, in other words, if this person can also manage the business, he's actually called a receiver, or supposed to be called a receiver and manager. And general receivership, usually this person will be appointed over all the company's property, and with the right to sell the assets. In other words, if the bank appoints this receiver, then all the other creditors will also come to this guy and say, hey, will you please handle our situation as well? And this is basically what general receivership is. And then at the end of the day, you will have the right to sell the assets. When we think about the receiver, we might ask ourselves, what will he do? What is his or her job? The general receiver will normally take control of the company's bank accounts and the insurance arrangements. And then the next thing, and very important, he will determine the property owned by the company and have it valued. People, it's interesting. I've done valuations for the bank, and as a valuer, you get normal market-related valuations, but at this stage, you basically do a forced sale valuation, which is way lower than a normal market valuation. And the only reason is a normal market valuation, you've got time to sell something. You've got time to invite people to come and have a look and get them interested and market the whole thing. But in this case, because of the limited time, you're basically just going to advertise it that there's going to be a bankrupt auction. And so basically you will only have a few interested buyers. And usually, or almost always, the prices will be way lower than market related. You will have to review uncompleted contracts, and you'll have to arrange for the continued supply of essential goods and services as a receiver. Receivers will have to pay wages and salaries. They will have to review the company's system of internal control and ordering, and they will have to sell assets of the company where and whenever it might be necessary. It's not anybody that can just be a receiver. Certain people are disqualified from being receivers, from receivership, and here we have to think about a body corporate. A body corporate can't be a receiver. A person under 18 years old, an undischarged bankrupt, person subject to compulsory treatment, or a mental health patient. If a person is under statutory prohibition from directing or managing or promoting, no closely connected person, say for example like a director or a shareholder of the company in receivership. Why? Because there will be a conflict of interest. No person prohibited by the document that grants the power to appoint a receiver. Who may appoint a receiver? People, it will be a secured creditor with a contractual right to appoint a receiver. So in my case, when I've been working for the bank, Barclays Bank, the moment that you've granted that credit to a client, you already make him sign the form, giving you the contractual right to appoint a receiver in case he's defaulting on his debts. In other words, a secured creditor with a contractual right to appoint a receiver in favor of the creditor, and you can appoint the receiver at any time after the underlying debt owed to the creditor becomes payable and when it remains unpaid. People, usually you go to the High Court or the District Court, but you only use this power as a last resort to preserve the property at risk or to enforce a judgment. On an event of default, non-payment of interest or principal, you can use it. A receiver must verify the validity of his or her appointment, and their solicitor will do this by reviewing the relevant security document, the notice of demand, and there should be sufficient related documentation in order to verify that an available event of default has occurred. Where a receiver has been invalidly appointed, the receiver may be liable for acts during the period he or she purported to act as a receiver. For example, where the security agreement under which he was appointed is invalid, or in the event where the event of default wasn't really, or where the event wasn't really an event of default. So this is why indemnification by the appointing creditor is so extremely important. The receiver is an agent of the company. People, this is an eye-opening statement, because the receiver is an agent of the company. The grantor is not an agent of the secured creditor. In other words, if we as a bank appoint that receiver, he's not working for us. He's still there to basically look after the best interest or pursue the best interest of that company. And this is normally stated in the security agreement and confirmed by Section 6.3 of the Receivership Act. The company, not the appointing creditor, is responsible for the acts and omissions of the receiver. So people, it's amazing that the receiver can walk into a company and basically take over. And so where does the receiver get this power from? How is it possible that he can walk into a certain company, take hold of certain possessions, sell it, and then pay the creditor the money to whom the money belongs? The powers of the receivers are derived from the security agreement or the court order under which the receiver has been appointed. So this powers, it can be expressly or impliedly conferred by the security agreement, and this remains the basis for the receiver's powers. But take in mind, there's also certain statutory provisions under the Receivership Act. What you have to see is that the powers expressly or impliedly conferred by the security agreement remain the basis of the receiver's powers. So Section 14.2 supplements these powers. A receiver may demand and recover income of the property in receivership, issue receipts for income recovered, manage the property in receivership, repair and maintain the property in receivership, inspect relevant books and documents, even if it's not in the hands of the grantor, insure the property, change the registered office or address for service of the corporate body. And keep in mind that Section 14.2 provides no power for sale. A receiver can't just go in there and start to selling the stuff of the mortgagee. It must be specifically granted in the security agreement. So remember that Section 14.2 supplements the powers of the security agreement. The Receivership Act in general grants the power to call up unpaid share capital that's covered by the security, and that's according to Section 15. You can apply to the court for an order authorizing the sale of the mortgaged property where the mortgagee refuses consent to the sale, according to Section 17. It will require the directors of the company in the receivership to provide assistance and produce and verify financial and other relevant information, according to Section 12. In other words, you can't decide as a director of a company that you're not going to cooperate with the receiver. The law requires you to assist him in whatever task he has to do. You can apply to the court for directions in relation to conducting the receivership if you're the receiver, according to Section 40. And you can continue to act as a receiver where the company is placed into liquidation, according to Section 31. The duties of a receiver: he's supposed to exercise his or her powers in good faith and for a proper purpose. In other words, in good faith, to the best interest of the company. But also exercise his or her powers in the best interest of the appointing secured creditor as well. In other words, he can't sell the property for a below market value to one of his friends because it's not allowed. And the general duties of the receiver is described in section 18. Section 19, the specific duties in relation to the sale of the assets. In other words, the receiver must decide on whether to sell the items collectively or separately. And he must try and obtain the best price reasonably by advertising it and so on. Some of the other duties of receivers: they have to give immediate notice of the receivership to the company and to the public according to section 8.1. All documents must state that the receiver has been appointed. In other words, after the name of the company, you will see the following words: in the receivership. It must be placed behind the name of the company, and that's according to section 10. And then you should keep money related to the receivership property separate from other money controlled by the receiver by running separate bank accounts. And that's according to the regulations of section 21. And you have to keep proper accounting records according to section 22 and prepare detailed reports for the debtor company and the secured creditor within 2 months after the receiver's appointment and every 6 months after the receivership. The required content of these reports is specified in the Receivership Act, sections 23 and 24. It seems crazy if they talk about every 6 months after the receivership, but just take in mind that some of these cases can take several years, especially depending on the size of the company. I know that MF Global, it took more than 4 years for everything to be finalized. Some other duties of receivers: people, they should apply the proceeds of the accounts receivable and inventory towards their own expenses first. In other words, it's very good for them that the law support them like that. And then the preferential creditors will have to be paid ahead of reimbursing the secured creditors according to section 30. So who's this preferential creditors? People, it's employees. So if you look at Schedule 7 to the Companies Act, amended by section 30 of the Receivership Act, you will see it's listing the unsecured creditors who must be paid before the secured creditors. And this will include employees, their wages, redundancy and holiday pay. And people, this can only go up to a total of 25,480 per employee. And I've checked that amount on the 6th of October 2022. And of course, IRD is part of this preferential creditors who will have to be paid first, even before the secured creditors. Where offences have been committed by the company or its directors, you should give notice to the registrar of companies according to section 28. I mean, if I say you, I mean as a receiver, if you're the receiver. And then the last thing, you should also give notice of the end of the receivership. Right in the end, when it's all ending, section 29, you should also give notice of that. Receivers should insist on being indemnified by the secured creditor who appoint him or her. The appointing secured creditor will typically undertake to reimburse the receiver for liabilities occurred during the receivership, insofar as the secured assets are insufficient to meet the liabilities and under the condition that the receiver acted honestly and not fraudulently. if a person dealing with an invalidly appointed receiver, unless a person has knowledge of the defective appointment, any transaction entered into between that invalidly appointed receiver and that person will not be invalidated, according to section 16.1. So, but the most important thing that I want you to notice, if you ever a receiver, insist on being indemnified. Otherwise, how else will you be compensated for losses incurred? A court may come to the rescue and may excuse the receiver from personal liability if the court is satisfied that 1. The receiver's liability was incurred solely by reason of defect in his appointment, and number 2, the receiver had acted honestly and reasonably in the circumstances. Take in mind that the contracts that the company entered into before the receivership will continue without personal liability. When leases continue for more than 14 days after the commencement of the receivership, then the receiver becomes personally liable, according to section 32.5 and 6. But he is entitled to an indemnity, section 32.9, and may limit his liability under a deed of indemnity, or seek to be excused from liability by the courts, section 32.7. By this time you know me, and whenever I write something in red, it means I'm trying to make you aware of something so that you can beware of certain pitfalls. And in this case, the receiver may become personally liable for wages and salaries payable under existing employment agreements, unless notice of termination is lawfully given within 14 days after the date of appointment. In other words, it will often happen that employees will receive letters of termination within 14 days after the receiver has been appointed, according to section 32.1b. So lawfully given, what does it mean? Lawfully given means the notice will conform with the provisions of the Receivership Act and the receiver's terms of appointment. And it does not mean that the notice must comply with the terms of the employment agreement or comply with the employment law. Very important. That's two different things. In other words, even if you receive notice and it's not according to the employment law or your employment agreement, you can have claims afterwards. But as long as the receiver, as long as he gives it according to the provisions of the Receivership Act. Usually a lawful termination under section 32.1b will amount to an unjustified dismissal by way of redundancy. And it's creating an unsecured personal grievance claim against the company in the receivership by the affected staff. Let's say, for example, maybe it's you or me. So the 14-day period, according to the previous slide, may be extended by application to the High Court, according to section 32.3 and 4. So if a director is entitled to remuneration under a contract, the receiver will also be personally liable for that remuneration if the receiver confirms the contract, according to section 32.1c. That's why it's better to fire that director immediately. It's not all bad news. Contracts entered into by the receiver during the course of the receivership creates a personal liability to the receiver, unless the contract expressly exclude or limit the receiver's liability. That portion, I've put that portion in green because I like that portion. And that's section 32.1a and section 2, subsection 2. In practice, receivers limit their liability to the assets of the receivership. In other words, that's what they will do. And they will exclude personal liability. The receiver is entitled, listen to this, to a statutory indemnity out of the receivership property, being the assets of the company. In other words, the assets of the company can be sold, and yeah, that will stand in for all this. For contracts entered into after his or her appointment, and for payment of wages, rent, and directors' remuneration according to section 32(9). I'm going to repeat some of this stuff, and this slide is basically just repetition. So the liabilities, wages, rent, the director's remuneration, and other receivership expenses take first priority over the proceeds of the secured property, and before payment to the other preferential creditors and secured creditors. A receiver will definitely require an indemnity from the secured creditor that appointed him or her, for in case the secured assets are insufficient to meet the receiver's liabilities and expenses. A range of statutory schemes of arrangement may be entered into voluntary by a struggling company that faces the prospect of a liquidation or receivership. Part 13 of the Companies Act provides that two or more companies may amalgamate and continue as one company, which may be one of the amalgamating companies or a totally new company. Important, after amalgamation, both entities must meet the requirements of the solvency test laid down in Section 4 of the Companies Act. A compromise with creditors may follow, as proposed by either the directors or by the liquidator or the receiver, or approval of the court. And you can read about that in Part 14 of the Companies Act. Or a company or its shareholders or creditors may apply to the court under Part 15 of the Companies Act, and the court may make an order that an amalgamation arrangement or compromise be binding. A company may also enter into an arrangement to restructure the share capital of the company, which can involve a consolidation of shares of different classes, or even a division of shares into different classes, but it may be subject to court approval. That's basically the end of receivership, and now I want to start to talk about liquidation. A company is placed into liquidation by the appointment of a liquidator at the initiative of the shareholders, the directors, or the High Court. Liquidation involves the liquidator selling off the company's assets and distributing the proceeds amongst the company's creditors, and if there are any funds left over, amongst its shareholders. Liquidation is also known as winding up. Liquidation commences on the date and time at which the liquidator is appointed, according to Section 2415. For the appointment to be effective, the liquidator must accept his or her appointment in writing according to Section 282. There's 3 types of liquidation. Shareholders can appoint a liquidator by special resolution, or the board of directors if an event occurred. There can also be an appointment by the High Court on grounds that the company is unable to pay its debts, or other grounds of Section 2414 of the Companies Act. The liquidator can also be appointed over a company in voluntary administration by resolution of the creditors at the watershed meeting. In the case of an event, and remember, an event will differ from case to case, and it's usually specified in a company's constitution, and it can often happen that a company can be liquidated and still be solvent. We talk about solvent liquidation, but a company's board or the shareholders may appoint a liquidator. And it will happen according to special resolution, and usually special resolution will be 75% votes unless the constitution requires a higher percentage. In other words, unless the constitution was modified by that company to fit their specific requirements. Liquidation or winding up is usually followed by a deregistration by the registrar. Sometimes a liquidation will be terminated by the court order, and then the company will not be deregistered. In limited circumstances, a company can be deregistered without first being placed in liquidation. Appointment of a liquidator by the courts. The application may be made under Section 2412C by the company, a director, a shareholder, or other entitled person, a creditor, including contingent or prospective. If the company is in voluntary administration, the administrator, or the registrar of companies. A company can refute the presumption of insolvency in the court. Under Section 287, the company is presumed to be unable to pay its debts if, and we've already discussed this, the company has not complied with a statutory demand. That's basically usually how it all starts. Execution of a judgment debt is returned unsatisfied. A receiver has been appointed by a secured creditor who is entitled to a charge over all or substantially all the company's property. A compromise under point 14 of the Companies Act has been voted on and was approved. We've already seen that the cause for liquidation, it always starts with a failure to comply to a statutory demand. We've already looked at that. Steps to follow. A statutory demand for payment is served under Section 289 of the Companies Act. A statutory demand must be in respect of a debt that is due, and it must be in writing and be served on the company and require the company to pay the debt or enter into a compromise under Part 14, or otherwise compound with a creditor or give a charge over its property to secure payment of the debt to the reasonable satisfaction of the creditor within 15 working days of the date of service, or such longer period as the court may order. So when that statutory demand was served on a company may apply to have the demand set aside if the debt is disputed or subject to set off, counterclaim, or cross demand. So disagreement must first be solved. The company must file an application to set aside the statutory demand in court and serve the application within 10 working days of service of the statutory demand. The court cannot extend this time frame. So we've seen that the statutory demand will be served, and then that company's got like 10 days to respond. And where the debt is not settled within 15 working days, the creditor has a further 30 working days to apply for the appointment of a liquidator and issue a new statutory demand according to Section 288(1). The unpaid statutory demand is evidence that the company is unable to pay its debt. So easy. So that's where it all starts. The statutory demand is served, and if that company cannot pay it, then that statutory demand will be the evidence that this company is unable to pay its debts. Keep in mind that the hearing of an application could be significantly delayed. The courts may then appoint an interim liquidator if this is necessary to maintain the value of the company's assets until the application is heard, according to Section 246. According to Section 241, 4b to d, you can appoint a liquidator when the company or board has persistently failed to comply with the Companies Act. The company does not comply with Section 10 of the Companies Act and does not meet the requirements to have a name, at least one shareholder or one share and a director. When it is just and equitable that the company be placed into liquidation. A shareholder or former shareholder may have it placed into liquidation as a remedy for oppressive conduct under Section 174. The effects of a liquidator's appointment: he will control the company's assets. The directors remain in office but cease to have powers, functions or duties other than assisting the liquidator. They have to assist the liquidator. Shares in the company cease to be transferred unless the court allows it. There will be no alteration to the rights of shareholders in this time. A shareholder must not exercise a power under the constitution of the company except for liquidation purposes. And very important in this time, the constitution cannot be altered. Who is allowed to be appointed as a liquidator? Section 280 lists persons who are disqualified from acting as liquidators unless the court orders otherwise. These persons include a company, a person under 18 years of age, a creditor of the company in liquidation, a person who has or whose firm has within the 2 years immediately preceding the liquidation, when it provided professional services to the company or had a continuing business relationship with the company, its majority shareholder or any of its directors or any of its secured creditors. The following persons are not allowed to be liquidators: an undischarged bankrupt, any person who is subject to compulsory treatment as a mental health patient, a person under statutory prohibition from directing, managing or promoting a company, a person who is closely connected, currently or within the past 2 years as director, shareholder, auditor or receiver with a company in liquidation or a related company, and a person who is prohibited by the court. The liquidator's main duties: you should take possession, protect, realize, distribute assets or proceeds to creditors, distribute surplus funds according to the company's constitution, and send a final report to the registrar for deregistration after above was finalized. Other duties of the liquidators: he or her should make sure that there is a public notice of his or her appointment. And he should report to the creditors, the shareholders and the registrar. And from now on, to make it easy, I'm just going to abbreviate it like that because I'm going to repeat it several times. There should be an initial report within 5 days after his appointment. And if he was appointed by the court, within 25 days. He should call a meeting of the creditors to confirm his or her appointment and appoint a liquidation committee. And he should report every 6 months to the creditors, the shareholders and the registrar. And he should regard the views of the creditors, the shareholders and the registrar. He should keep accounts and records for liquidation company, for the liquidation company. And there should be a final report to the creditors, the shareholders and the registrar. And he should report any offence by a director to the registrar. Unfortunately, and I believe you've already seen it, this is a fiduciary position and he owes fiduciary duties. In other words, he will have to act in good faith, for a proper purpose, impartially, must receive assets on trust for the benefit of all creditors in accordance to statutory provisions. The liquidator's powers. People, if we look at the liquidator, first of all, there's administrative powers. He's got a wide range of enabling powers for his duties. He can sell or dispose of the company's property, carry on business for purpose of liquidation, compromise with creditors. He can basically initiate proceedings in the name of the company, can borrow money against the company assets, call meetings of creditors or shareholders, the power to obtain documents and information about and property of the company. People, a liquidator has got the power to make calls on shares and enforce shareholder liabilities, to disclaim onerous property contracts and end all the rights, interests and liabilities of the company in relation to a property or contract. The liquidator can pool assets of related companies or get a related company to contribute towards the debts. The liquidator can require supplies of essential services and assign the right to sue conferred by the Companies Act to a third party, including the rights to sue directors under the insolvent transaction provisions of Section 260A. How are the funds distributed? Make sure that you read through and study Schedule 7 of the Companies Act. You will see Walker differs. Walker, your textbook, differs from the legislation, but the correct order is in Schedule 7 of the Companies Act. 1. The first people who will receive their money is the money that will be paid is the expenses of the liquidation. In other words, the liquidator will first pay himself. Then the secured creditors will be paid. Then payments to preferential creditors. There's the employees are included over there. And then the unsecured creditors, and only then the shareholders will share in the remaining assets. What about secured creditors? Under Section 305, a secured creditor has 3 options in a liquidation: realize its secured property, sell the assets subject to its charge, recover what is owed, and either account to the liquidator for any surplus or prove its debt along with the unsecured creditors if there is a shortfall. Value the security and prove it in the liquidation to qualify for any shortfall as an unsecured creditor. The liquidator must accept the valuation in order for this option to proceed, or surrender its security to the liquidator for the benefit of creditors generally and prove in the liquidation for its debt as an unsecured creditor. This option may be attractive if the security is of little value. In other words, rather go stand in line with the rest of the people if you see, okay, this thing is really not going to sell for much, you're never going to get your money back. Let's look at the preferential creditors. Preferential creditors are paid after the secured creditors. In other words, the first creditors that will be paid is the secured creditors. And then second, obligations include the expenses of the liquidation, which must be paid first, and then it will be followed by such payments as wages and holiday pay, child support deductions, lay-by sales repayments, cost of creditor meetings, and certain unpaid tax and custom obligations. The claims of preferential creditors rank equally and must either be paid in full or, if the funds are insufficient, obeyed in equal proportions to the debt owed to them. When it comes to the unsecured creditors, if some funds are still available after the secured and preferential creditors have been paid, the ordinary or the unsecured creditors will receive some or all of the money that they are owed. If there are sufficient funds to pay all these unsecured creditors all of the money they are owed, they will be paid in full. But if there are insufficient funds to pay them in full, they will be paid proportionally. Some of you might wonder, how will a creditor prove a debt? A creditor simply proves a debt by submitting a claim to the liquidator under Section 304 of the Companies Act, and the claim must be in the prescribed form and contain full particulars of the claim and identify any documents that support it. Sometimes there can be surplus assets. It often happens. Shareholders will then receive the surplus. The size of what they will receive is depending on the type of share that they are holding, and it is important to know what the company constitution says about the distribution of the surplus assets on liquidation. So we've looked at receivership, we've looked at liquidation, and now we're going to look at voluntary administration. People, I like this one the most. It's part 15 of the Companies Act, and it's introduced by way of the Companies Amendment Act of 2006. What is voluntary administration? Voluntary administration is a mechanism by which an insolvent company can enter a temporary safety zone or moratorium. See that I've put it in green. From creditors' claims, while a considered decision is made by its creditors on whether the company should 1. Execute a deed of company arrangement, or as alternative be placed into liquidation, or as alternative be returned to the control of its board of directors. So what is a deed of company arrangement? A deed of company arrangement may be appropriate where creditors believe that the company can trade out of its financial difficulties, or where it is possible to restructure the company by selling off some business operations over a period of time. A deed of company arrangement, a DOCA, people, it's simply that agreement between the creditors and the company where they determine how the company affairs will be dealt with in future, which may be agreed to. In other words, this arrangement may be agreed to as a result of the company entering into voluntary administration. The DOCA binds all unsecured creditors, even if they voted against the proposal. In other words, it's just like democracy. Even if you vote against it, at the end of the day, you have to go with the majority. So what is the purpose of voluntary administration? People, basically it's twofold. And first of all, it's to provide for the business, property, and affairs of an insolvent company, or a company that may in the near future become insolvent, to be administered in a way that, first of all, maximizes the chances of the company, or as much as possible of its business continuing in existence, or B, if it is not possible for the company or its business to continue in existence, at least there can be a better return for the company's creditors and shareholders than would result from an immediate liquidation of the company. In other words, first of all, we try to secure the business to continue. We want to basically assure the continuance of the business, but if we can't do that, at least we want to make sure that the creditors get the best possible return. Voluntary administration is actually not a difficult topic. There are two phases that can be distinguished in voluntary administration. First of all, we have the administration phase, when the company has administrators appointed. and then the deed phase. In other words, we've already talked about it, DOCA, the deed of company arrangement. Assuming the company enters into a deed of company arrangement. When the company is subject to a deed of company arrangement, that's basically what the deed phase is. So first of all, the administration phase, and then the deed phase. Very easy. The company will be in administration. In other words, the first phase, from the moment the administrator is appointed until, people first, a deed of company arrangement is executed. In other words, that's one of the options that can happen. The second option that can happen is the company's creditors can appoint a liquidator to the company. It's not good news, but that's why I've put it for you in a different color, because it's a different option. It's not like the first option where a deed of company arrangement is executed. And then people, the third and the last option, the company's creditors resolve that the administration should end. And they say, no, the control of the company should be returned to the board of directors. So these three options are what creditors vote for at the watershed meeting. In other words, people, the watershed meeting is absolutely going to determine the continuance of the possible continuance of the business or not. Everything depends on that watershed meeting, what will happen next. And that's where the name comes from. This is now interesting, but after the administrator was appointed and until that watershed meeting, the company must put administrator appointed after its name. So for that whole administration phase, remember administrator appointed behind the name of the company. If the company enters into a deed of company arrangement following the watershed meeting, then from that meeting onwards, it must state these words on all correspondence, subject to deed of company arrangement. So in other words, if there's a DOCA agreement, subject to deed of company arrangement. Who appoints the administrator? People, the company through the board of directors will do it. And this is usually how it will start. And from there we talk about voluntary, because it's simply a voluntary thing. The directors themselves decide, no, we're not going to take the risk to go on trading in the company if our assets exceed our liabilities, or if we cannot pay our debts as they become due to liquidity problems. Whatever the case may be, but the board of directors will make that decision and they will make it voluntary. A liquidator or an interim liquidator can do this after liquidation started. And even a secured creditor can do this if they have a charge over the whole or substantially the whole of the company's property. But remember, they cannot appoint an administrator once the company is already in liquidation. People, and the court can also do it on the application of a creditor. And the court will only do it if the court is satisfied that it is likely to result in a better return and it is just and equitable appointing an administrator. So who is allowed to be appointed as an administrator? People, only a natural person, and only a natural person who is not disqualified may be appointed as an administrator. So unless the court orders otherwise, a person is disqualified from appointment as an administrator if that person is also disqualified from being appointed or acting as a liquidator under Section 280 of the Companies Act of 1993. And we know, I've already spoke to you about this. Say, for example, if the person is a creditor of this existing company, or maybe he was a director within the past 2 years, or maybe an auditor of this company, or there's a very close relationship with a company of some other kind. Maybe he's like in shareholding. So there's many different reasons why a person will be disqualified according to Section 280 of the Companies Act, and you can go read it. It's interesting. If the person is prohibited by court order on the basis that they are unfit to act as an administrator by reason of persistent failures to comply with an enactment, rules of court, or any order or discretion of the court, or the seriousness of a failure to comply. So a person in a continuing business relationship with a company, its majority shareholders, directors or secured creditors, all these people need court approval before being appointed as an administrator. The administrator must table an interest statement that discloses whether the administrator or a firm of which the administrator is a part has a relationship with the company, irrespective of whether it's a personal or a professional relationship. The effect of an appointment of an administrator, people, it does not mean that the directors are removed. However, they cannot engage in management functions unless the administrator gives written approval for them to be able to do that. The administrator during the process of administration will have control of the company's business, control over the property and affairs, people, and this is all according to Section 239U. So once an administrator is appointed, what can he do and what's he not supposed to do? So the administrator may carry on the company's business and manage its property and its affairs. And he may terminate or dispose of all or part of the company's business and dispose of any of its property, and perform any function and exercise any power that the company or any of its officers could perform or exercise if the company were not in administration. People, and you'll find that in the Companies Act of 1993, Section 239U. What happens at the very first meeting of the creditors? So the first meeting, people, it's important that it must be held within 8 days after the commencement of administration. So that's very quick. During that meeting, they will decide whether to replace the administrator or not, and decide whether to appoint a creditors committee, and if so, if they decide they're going to appoint a creditors committee, they will appoint the members of that committee. And the purpose of this committee is that the administrator can report to them, but they are not allowed to give this administrator directions. As soon as practical after the administration begins, the administrator must investigate the company's business, the property, the affairs and financial circumstances, and he must form an opinion as to whether it would be in the interests of the company creditors to basically for the company to execute a deed of company arrangement, or for the administration to end, or for a liquidator to be appointed. Always those three options. A key task for the administrator at this stage is to estimate the possible amount of money that could be clawed back under the voidable transaction provisions if the company were to be placed into liquidation. So the voidable transaction provisions are only available where a company is in liquidation and not where it is subject to a deed of company arrangement. But assessing the potential recoveries for creditors from voidable transactions is therefore an important way of comparing the merits from the creditor's point of view of a liquidation versus a deed of company arrangement. Some of the effects that will be seen and felt when an administrator is appointed. First of all, the employee's contracts are not automatically terminated, but the administrator is not personally liable to pay wages, and that's according to the Companies Act 1993, Section 239. Why? Transactions involving the company's property are void unless approved by the administrator or validated by the court. People, and this is of course to make sure that some of the property will not disappear or will be sold at below value because the people expect the worst. So this is really with regards to fraud prevention in mind. Shares may not be transferred or shareholders' rights altered unless the administrator considers it to be in the best interest of the company, according to the Companies Act 1993, Section 239 AB. And then, of course, people, the moment that an administrator is appointed, liquidation is suspended. In other words, first of all, we're going to try administration or voluntary administration. Before, if we later on say, okay, no, we basically have to go for liquidation, then that will be the next phase. Always remember that the company's property is protected during the administration period. And you might say, why? And we've already talked about this, but to enable the company in administration to have a reasonable chance to propose a deed of company arrangement to its creditors. In other words, that's where they will tell the creditors, this is how we're going to pay you back, and make a proposal to them. And then the creditors can decide, okay, no, we're not going to accept it, or yes, we're going to accept it. The Companies Act provides a kind of a safety zone for the company during its administration period. So while a company is in administration, there are restrictions on liquidation. Remedies of secured creditors are restricted. In other words, they will have to wait. Remedies of the owners and lessors of property used, occupied by, or in possession of the company are restricted. Legal proceedings against the company are restricted. Enforcement processes are restricted. In other words, it's that period, that safety period, that the administrator or the company can basically sort out everything. So two things, we've already spoken about that. No director can act unless they have the permission of the administrator. And with regards to the shareholders, they cannot transfer the shares unless they have the consent of the administrator. If we look at creditors with a charge over the whole or substantially the whole, people, they are supposed, such a creditor is supposed to enforce their charges within 10 days after the appointment of an administrator. And if one of those creditors are too late, then they are simply prohibited. Then they will have to wait. So people, you can see that it's very important for a successful voluntary administration. We require the support of secured creditors. The company will require their support. And the only thing that you can do is to go and discuss it with them before the administration period even begins. Because if you can get their support, people, it can go through. But without their support, you won't make it. Secured traders with a charge over perishable property can enforce the charge. So remember, during the administration phase, these creditors are restricted from basically playing out their rights. But once the company is out of administration, secured creditors are no longer barred from enforcing their security. However, companies under liquidation have its own restrictions. If an administrator breaks the fiduciary duties, people then is liable to pay compensation or even a civil penalty. So the administrator is liable for all debts incurred during the performance or exercise of his functions and powers, where those powers are exercised to fund the company, services rendered, for goods bought, and for property hired, leased or occupied. If a company is leasing property, the administrator will be personally liable if it continues with this contract more than a week after the administration commenced. So the administrator must lawfully give notice to employees, and otherwise he will be personally liable under the employment contract where he or she adopts the agreement in writing. And then indemnity. You all know what indemnity is. In other words, that's where the administrator will try to protect himself. The administrator is entitled to an indemnity out of the company's property for personal liabilities incurred in due performance of his or her duties. Unless, in other words, there will be no indemnity if he or she acted in bad faith. In other words, we've seen the importance of the fiduciary duties, but if the administrator acted in bad faith, there will be no indemnity. How is a company's property protected during administration? To enable a company in administration to have a reasonable chance to propose a deed of company arrangement to its creditors, the Companies Act provides a kind of a safety zone for the company during its administration period. Therefore, while the company is in administration, there are restrictions on liquidation, and the remedies of secured creditors are also restricted. We've already spoken about this a lot. This is good repetition because it is important. And it's still continuing. The remedies of the owners and lessors of property used, occupied by or in possession of the company are also restricted. In other words, you can't just go in there and take your property because you're not allowed to. They will first sort it out and say, okay, we really see this is not fraud, now you can take it. So there will be a stage. But for now, in the beginning, guess what, people? It will be restricted, that safety period. Legal proceedings against the company are also restricted. Why? Because everybody knows they're in trouble. Enforcement processes are also restricted because people, if you don't give them a chance, how can they recover? This whole thing will have to be investigated by somebody who knows. What is the relevance of the watershed meeting? We've already spoken about that. The Companies Act of 1993, sections 239, and there basically AS, AT, AU, and AV that you can look at. But the watershed meeting is a meeting of creditors called by the administrator to decide the future of the company, and in particular, whether the company and the deed administrator should execute a deed of company arrangement. One of the tasks of the administrator is that he's supposed to convene the watershed meeting. And he must do it within that convening period, and which is within 20 days after taking over as administrator, or within 20 days after the date on which the administrator is appointed. And it includes any period for which it is extended by the court. the administrator must convene the watershed meeting by giving written notice of the meeting to as many of the company's creditors as reasonably practicable, and advertising the meeting in accordance with Section 3(1)(b). So what is decided? Again, at the watershed meeting, people, you must decide to enter into a deed of company arrangement. That's basically the thing. Are we going to go for a deed of company arrangement or not? Are we going to place the company in liquidation, or are we going to hand it back to the board of directors with everybody's consent? If the creditors fail to make a decision, the company reverts back to the control of the board of directors. The creditor's decision is assisted by a report prepared by the administrator and setting out the company's business, property, affairs, and financial circumstances, and any other matter that the administrator considers to be material to the creditor's decision at the meeting. The administrator's report must include a statement setting out the administrator's opinion. In other words, he must guide the group. He must make suggestions with reasons as to which one of the three options will be in the creditor's best interest. In other words, he must show them evidence and say, I think we should go for this and this option. And how does the deed of company arrangement come to an end? By a court order, or by creditor's resolution, or under the terms of the deed. Some of the ideas that I want you to ponder on, because think about it, one of the advantages in my eyes is the difference between an administrator and the receiver is that the administrator will seek to protect all the creditors. But the receiver, on the other hand, is only concerned with secured creditors. Administration can be used by boards of companies in financial difficulties as a means to avoid a breach of directors' duties. In other words, people, you know that you can't keep on trading if a company is like insolvent, and this is exactly why we can make use of administration, because then we can prove to everybody, basically, there's a big chance that we will trade this company out of its trouble. Just give us a little bit of time. But at the least then, you will not be personally liable for reckless trading. And yeah, one of the reasons why we make use of administration, we can often avoid the liquidation of the company.